Public and private collaboration is a simple concept that's very difficult to accomplish. As we saw in PDD 63, we established a concept of sharing information and intelligence, but what are the problems that we're seeing? Well, certainly anonymizing the data to protect privacy is very important. People tend to want to share data if other people don't know it came from them. A true way of sharing that information. How do I get my information from me to another person or another agency that's trying to protect the information? And reluctance on the part of private companies to participate, and the piecemeal organizations on the public sector side. Around 2015, the practice started to come together. But we still see numerous agencies responsible for cybersecurity. For instance, at the FBI, there's the InfraGard, Internet Crimes Complaint Center, the National Cyber Forensics and Training Alliance, the Secret Service, we have the Electronic Crimes Task Force, Department of Defense, we have Cyber Command, Department of Homeland Security, we have the Office of Cybersecurity and Communications. At the Justice Department, we have Computer Crimes and the Intellectual Property Section. U.S. Department of Commerce, we have the National Institutes of Standards and Technology, and even the U.S. Energy Department is involved in the process with their CRISP program. The point is there are many different voices that need to be heard, and it's difficult to bring all of those voices together from the public sector effectively to communicate threats to the private sector. The National Cybersecurity and Communications Integration Center, the NCIC, encompasses the U.S. Computer Emergency Readiness Team, or the U.S. CERT, which provides a 24-hour monitoring of emerging cyber threats, communicates these out to the subscribers regarding the observed threats. Under the Cybersecurity Act of 2015, the DHS has assumed a central role in coordinating cybersecurity monitoring and alerting. They've encouraged the private sector to participate and provided limited legal immunity to private sector companies reporting events. And they've expanded the role of the NCIC and assigned the responsibility of cybersecurity planning to the NCIC and DHS. Many of the agencies that I listed in the earlier slide have a seat at the NCIC to help coordinate cybersecurity activity that they observe. Private industry has been reluctant to share information with the public sector. Probably the most compelling reason that we see companies establish that reluctance is the fact that participating in a sharing process could impose a liability on the company. So if they spot something or someone else spots something and you see it, does the fact that you have knowledge that a particular threat exists impose a duty upon you to act against that threat? That's kind of the question that needs to be answered under that particular aspect of reluctance. There could be antitrust issues. Certainly, this was a question that was presented as the ISACs were developed, for instance, the FS ISAC or the Health ISAC or whatever. When you're thinking of bringing all these companies together to share threat data, you have to be very careful that you don't walk over the line and create an antitrust scenario. That's why when you go to these ISAC meetings, you'll very seldom ever hear anyone mention products or various products in the marketplace, because that could create that antitrust scenario. And certainly privacy, violation of privacy. If you expose private information in the process of sharing. The Cybersecurity Act of 2015 creates new processes for companies to monitor and defend their networks, however. Creates a new platform for the exchange of information between the public and private sectors, such as cybersecurity indicators and defensive measures. Limited liability or limited immunity applies to the sharing of cybersecurity indicators and defensive measures. These indicators are information used to describe or identify certain types of acts, such as malicious reconnaissance or methods of defeating a security control or exploitation of security vulnerabilities or identification of security vulnerabilities, phishing, malicious cyber command and control networks that are being set up, actual or potential harm caused by an incident, including exfiltrated information, or other attributes of a cybersecurity threat. Some of the threat indicators that you might share, or we do share, are things like IP addresses, malicious URLs, log extracts showing failed attempt to log into users' accounts. You don't want to show the user's name necessarily, but you can show the data associated with the individual or party that's trying to make those login attempts. Log extracts showing successful login to a user's account at a time when a user wouldn't normally log into the system. Certainly, again, you wouldn't want to share the login information, but you could share the indicators that surround that particular episode. And domain names, like I said, associated with malicious or suspicious activity. We call these use cases when we're using them to design defensive measures. For instance, with our security event monitors or our firewalls, intrusion detection and prevention systems, we build out what we call use cases, or examples of things that we want to block with a particular rule or establish a monitoring pattern for. Defensive measures are actions, devices, procedures, signatures, techniques, or other measure applied to an information system or information that is stored on a system, processed by or transiting on a system that detects, prevents, or mitigates known or suspected threats or security vulnerabilities. It expressly does not include measures that destroy, render unusable, provides unauthorized access to, or substantially harms an information system or information stored on or processed by or transiting a system not owned by the private entity operating the defensive measure or other entity acting on its behalf. So in essence, it's a process that allows you to detect, prevent, or mitigate known or suspected threats, but without harming the computers that are generating the threat. You see laws occasionally pop up in the Congress for active defense measures, which are basically allowing you to go out and analyze where threat activity is coming from. There's very specific, in all of these laws that I've looked at, there are very specific protections and warnings against harming the other computers that you may be looking at, even if it is the person's computer in another country who executed the threat directly against you. So you have to be very careful if you're looking at active defense measures. As stated, the Act provides limited legal immunity for companies that share information with the public sector. If a company complies with the provision of the Act, it will not be held liable for monitoring its systems for cyber threats or properly sharing or receiving cyber threat indicators. It only applies if sharing information for cybersecurity purposes, however. So a cybersecurity purpose is a purpose of protecting an information system or information stored on or processed by or transiting on a system from a cybersecurity threat or security vulnerability. Cybersecurity threat can be an action not protected by the First Amendment on or through an information system that may result in an unauthorized effort to adversely impact the security, availability, confidentiality, or integrity of an information system or the information stored on or processed by or transiting a system. Cybersecurity threat does not include a violation of the customer terms of service or licensing agreement, and the companies cannot gather and share private information with the government. So you cannot share things like credit card data or the banking information, and you have to be very careful about sharing even individuals' names or any other confidential information that you may store as a process of your business. So you have to be very careful and talk with your legal counsel to ensure that what you are sharing is not considered private information that you would be passing on to the government. There are caveats to limited immunity. You must comply with DHS procedures. You have to prevent information from authorized access. You have to review cybersecurity threat indicators before sharing them out to ensure that what you have really are threat indicators. And remove any information that's not directly related to that cybersecurity threat. Most importantly, the Cybersecurity Act of 2015 does not create a duty to act. The private sector can use the shared information to affect a security change or not. The private sector is not required to share cyber threat information or use the information that they receive. It's up to them. The DHS created the Automated Indicator Sharing System for sharing and receiving cyber threat indicators, but this is still gaining ground and is not what we normally see in the process of sharing data at this point. The Energy Department also has cyber threat information that they can share. And certainly would like to receive information from companies that are in the energy utilities business. And there's a serious threat if in the national security if the electric grid is disrupted. You could imagine if you've seen some of the risks that were posed in or seen just from the loss of power in 2013 up in the Northeast, a massive amount of economic impact for a very short 29-hour outage. So you can imagine if there was a much more damaging attack on the power grid, there could be a serious economic as well as the national security impact on the country. 2013, the U.S. Department of Energy developed the CRISP program, Cybersecurity Risk Information Sharing. It's a voluntary program for sharing classified, non-classified cyber threat data with the Energy Department as an intermediary. The Department of Energy recognized cyber threats for their disruptive potential and put this program together so that they could share and receive data from the various utility companies.